Hey, this is Lee and Cooper, and we're back with another In Brief. Happy Father's Day, Cooper.
Happy Father's Day, Lee.
Today we're going to talk about the state of commercial leases, particularly litigation surrounding commercial leases. Obviously, the courts reopened a couple of weeks ago, and there's been a flood of plenary proceedings by landlords against tenants. But today we're going to talk about what actions tenants can take, affirmative actions tenants can take in both federal and state court with respect to their commercial leases. So I think Cooper's going to talk first about a federal case, and then I'll talk about a state case, and we'll go from there.
Yeah, one of the cases we've been following most closely is this Brooklyn Boulders case in Williamsburg, where Brooklyn Boulders was building a massive new space. It was going to be a co-working, a fitness facility. They were going to do a number of different things, and after several months or several weeks, it sounds like, trying to negotiate a termination of the lease once COVID struck, they were ultimately unable to reach any kind of agreement with the landlord. And so the tenant in that case filed an action to rescind the lease, arguing that the purpose of the lease was frustrated because of the governor's orders and the various restrictions that will be in place because of COVID. Again, this was the tenant that filed the action. And at this point, not much has happened in the case, but it is an interesting strategy. And really what is noteworthy, though, is that it is their argument is very specific to the actual purpose of their lease, which was to have a fitness facility and to have this co-working space. And because of the governor's orders, even though they may be able to do some version of that, they won't be able to do the version that they envisioned. And so that is their argument, that because it's not what they specifically contracted for, the purpose of the lease is no longer valid. And so, well, it's certainly a case we will continue to watch.
Yeah, I mean, it's a very similar strategy employed by the case that I'm going to talk about, which is Victoria's Secret versus Herald Square. Not Herald Square, the actual square, but their landlord is Herald Square, making the same kinds of arguments. And what's really notable there is they really focus on two pieces. Just like in Brooklyn Boulders, they focus on the purpose, and they also focus on the location. I think they make some really good location arguments that are transferable to a lot of different kinds of stores. Because look, obviously Herald Square has changed in terms of the amount of foot traffic. Victoria's Secret and Herald Square, I'm sure, was very dependent on a lot of tourists and foot traffic in the area. But New York City in general has always depended on a lot of foot traffic. And if you just walk outside, I live in Brooklyn, Cooper lives in Brooklyn. If you walk outside, foot traffic has substantially diminished throughout New York City, Brooklyn, Manhattan, Queens. So I think the argument that they make, which is less people, the purpose of a really expensive lease in Herald Square was to be able to reach out to all these tourists who were getting off of the subway and were right there in the middle of the action. You can make the same arguments for virtually every retail business in New York City. They've been affected in some way by a substantial decrease in foot traffic. And they engaged in these really expensive leases because they were relying on New York City foot traffic to keep them afloat, and that's no longer the case. So Victoria's Secret is doing the same thing as Brooklyn Boulders, except they went to state court because they filed after the state court stay was lifted in terms of new filings, seeking rescission of the lease, seeking the court to declare that the purpose of the lease has been frustrated, seeking to claw back some of the money they already paid for March rent, because their argument is the pro rata portion of March rent after the governor shut down is an unjust enrichment to the landlord. And they also focused on the purpose of the lease. So, being a high-end retail store, which they can't do it all right now, and they won't be able to do it in the same way that they had done in the future. So even though we're talking about Victoria's Secret, most small businesses are not operating at the same level, don't maybe have the same kind of really expensive lease that Victoria's Secret has. The same kinds of arguments on a smaller scale we think are transferable to tenants throughout New York City, and I think we'll be seeing those arguments made by smaller tenants in the weeks and months to come.
Absolutely. Certainly, we will be watching the space closely and plan to continue updating you in the coming days, weeks, months ahead. I'm sure if there are any breaking decisions on this specific area of the law, be sure to, we will certainly be sure to let you all know. And if you have any questions, you can always reach us via phone or email, and we look forward to hearing from you. Take care. Enjoy your weekend. Bye-bye.